The second thing I really want to talk to you about, and I've already touched on it, and look, you probably already know it, but I'll just say it, is how do citizens become jurors? I'll try to keep the cracks to a minimum so we can listen. How do they become jurors? Well, I've already told you that if you're on the electoral roll, you have as much of a chance as me of getting an eligibility questionnaire. Providing you're eligible, you're not disqualified, and you're available, you will get a summons. Once you have a summons, you come to the court on the day the summons says to come. Now, it's a numbers game, and it's a random selection all along the way. So we'll send out, I'll just talk about Melbourne, we'll send out 70,000 questionnaires a year to get about 25,000 summonses out, to get about 15,000, 12,000 people actually in. Because, as you can appreciate, they might fill out a questionnaire that says, yes, I'm available, and then by the time they get the summons, they've won the lottery and they've moved to Tahiti, or they've got a different job, or whatever. So people fall out along the way. And once they're, I've already hinted at it, once they're in the courtroom, they're in a pool room like this. So if we had, I'll make it up, but if we had 5 trials starting one morning in Melbourne, we need to bring in about 125 people or so. So it's not 5 times 12. Right? It's not 5 times 12 is 60. We bring in about 125, maybe 130 people. And that's because people are then randomly drawn from the pool room. So to get 12 in the courtroom, in the box, we'll send up 35 or so people to the courtroom. 12 will stay, 23 will come back. They're back in the pool. It's sort of a moving feast. And then they could be randomly selected again out of the pool room to go to another courtroom. So what we tell citizens when they come into jury service is thank you for making yourselves available. We always remind them the average length of a trial is 7 to 10 days, so thank you for making yourselves available for the average length of a trial. And then we say to them, you will have one of 3 experiences. You will either get balloted out to a courtroom once, twice, 3 times maybe, and not get on a jury. You might get balloted out once, twice, or 3 times and find yourself on a jury, or you may never leave this room. And thank you very much. Here's your 40 bucks. And go home. Okay? Have you heard of any of the work that the Victorian Law Reform Commission is doing with respect to the empanelment of juries? Just one person nod, yes or no. And I'll listen. Yeah? No? Yes? I beg your pardon? They're trying to reduce the amount of time they're taking, and they're actually looking, and that's not the only motivation, but, and what they're looking at are 3 aspects of the jury empanelment process. And the only reason I mention it is 2 of them don't really matter to what I want to say. They want to look at whether you ballot by number or by name, because currently in the courtroom, the judge can call your name, Paul Dore, public servant, or they can call number 22, public servant. The second thing that they're looking at is whether more than 12 people can reach the decision. Because in longer trials, judges can empanel up to 15 people, assuming natural attrition. Life got in the way, so one person can, you know, there's 15 of us on a jury and I get hit by a bus. They say, okay, that's fine, we're down to 14, thank you, you know, and they just, so the idea is that natural attrition will get you to about 12 at the end of a long trial. But what happens is if you get to the end of the long trial and nobody's been hit by a bus, you got 15 people. And then you have to ballot off 3 of them to get down to 12. And I can tell you as somebody who, well, not routinely, but I am the person I like, let me say it a different way. I prefer to be the person who discharges those people who have been balloted off because I think it warrants my level of authority to talk to these people who are almost to a person, incandescent with rage. They are outraged because they say, how dare you bring me in for 2 or 3 or 4 months, 9 months sometimes on a trial, ask me to pay attention, ask me to listen to everything, only to ballot me off and send me home and not be part of the decision. Every now and then you get the person who go, oh, thank God, I didn't want to be part of that decision and I'm glad I'm gone. But most times people are quite outraged. So the Law Reform Commission is looking at whether 15 or 14 or 13 can make a decision like 12. Because, by the way, if we start with 12 and I get hit by a bus, the judge can determine that 11 can make the decision, or even down to 10. Okay? But the third thing I just wanted to say about the Law Reforms Commission's work is your expectation if you do go into court, and it's around this idea of peremptory challenges. Is there a nod that anybody sort of knows what they are? It's basically I'm accused of something, and I have the right to challenge any one of you who are in the panel. Your name comes out in court, you know, Lucy, student, she gets up, and I'm allowed to challenge her. Now, they're looking at whether challenges are good, bad, or otherwise. Whether if they're good, can you do it better? And by the way, there's 6 challenges, peremptory challenges. And I think that's the reason for that is, and I'm not a lawyer, I'm not a judge, but if some believe that the right of the accused, many believe the right of the accused to have some control of who ends up on the jury. Okay? So what we say to citizens around peremptory challenges, don't take it personally, okay? Because they don't have to give a reason. So here you are to do your civic duty, your name comes out of the hat, you get up, and before you're in the box, somebody says, the accused or his, no, it's the accused says, I was going to say the lawyer, but the lawyer is often with them, but the accused will scream out, challenge. And then you have to sit back down. So we say to citizens, don't take it personally. It's that person's right to challenge, and don't worry about it.